Good morning and welcome to the Tennessee Court of Appeals. We appreciate both you and your clients agreeing to participate in this oral argument via Zoom. We hope that it's the most efficient way to resolve these cases in the times that we're living. We need for you both, being experienced practitioners, to understand that the rules and the procedures of the Court of Appeals are applicable here, and we will be conducting ourselves as if we were standing in the courtroom all today. Each side will receive 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with Mr. Hibner, you'll receive that rebuttal time. Before we get started, I need to introduce our panel. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything before we take up this case?
I know, Your Honor.
You may call the case then.
First Community Mortgage, Inc. versus Appraisal Services Group, Inc. et al.
And we will hear from the appellant.
Good morning, Your Honors. My name is Ben Lewis. I represent the appellant in this matter, First Community Mortgage Incorporated. I appreciate you all being here today, and it's nice to be in front of the court once again. This case centers around a dispute between several parties, two of which are the appellees, Appraisal Services Group Incorporated and Deanna Miles, one of their appraisers. A property was purchased in Weakley County, wherein our clients issued a mortgage that was subsequently purchased from other lenders down the road. Due to a defect that we claim in our complaint was based upon the negligence of Ms. Miles in doing her appraisal and by agency, the appraisal group that hired her, an issue that arose wherein there was a significant encroachment that caused the subsequent purchasers of the loan to cause everyone in the line of succession to rebuy the loan. Ultimately, our client, First Community Mortgage Incorporated, was forced to repurchase that loan. As a result of these issues, a foreclosure sale ultimately occurred on the property. And in June of 2019, June 7th exactly, a foreclosure sale was held and our client suffered damages in the approximate amount of $100,000. We filed this suit in September of 2019. After several motions, it was moved to Weakley County in West Tennessee, and hearing was held on a motion to dismiss the amended complaint in July of 2020, and a dismissal of the amended complaint only regarding the two appellees here today was issued by the court on August 12th of 2020. The issues at hand brought forward in the motion to dismiss was that Tennessee Code Annotated 283104D, which applies to appraisers and negligence from their appraisals, time barred the case filed by the appellants, which was filed in September 2019. The trial court ultimately dismissed the case, finding that the statute of limitations applied, that the right of action had accrued prior to the 1 year within the suit had not been filed, and the case was dismissed. The appellants we set forth two arguments in our brief and made those arguments to the trial court regarding why the statute of limitations in 283104D did not apply to our case. It is the position of our client that the trial court erred in dismissing our lawsuit because that statute of limitations set forth there should not have applied. And the first reason we set forth was that statute 283104D, which in pertinent parts states that any action to recover damages against a real estate appraiser out of that appraiser's real estate appraisal activity should be brought within 1 year from a person's discovery of the act or omission giving rise to the act. The compiler's notes to that statute specifically state that it is applicable to actions accruing or appraisals conducted after July 1st of 2017. Appellants contend that the application of that statute to our clients is a retroactive application, which would be unconstitutional. pursuant to Article 1, Section 20 of our Tennessee Constitution, when a statute creates a new right, takes away a vested right, or impairs a contractual obligation, its retroactive application is constitutionally forbidden. This Court of Appeals, in the case of Gunter v. UCHRA, dealt with the issue of when a cause of action is barred by a statute of limitations, which was in force at the time the right to sue arose. The right to rely upon the statute as a defense is a vested right. When taken in the inverse, which is what this case essentially is, meaning that when a statute of limitations was not in effect at the time and someone had a right to sue at that time, and a subsequent statute modifies the statute of limitations, that would be removing the vested right from the claimant. In this action, if the statute applies, meaning 28.3104D, and applies a 1-year statute of limitations, then doing so to an appraisal that occurred prior to the statute being enacted, because this appraisal occurred in August of 2015, would then remove the appellant's right to bring suit.
When did your client become aware of the problem with the appraisal?
Our client became aware of the problem. I believe that the issue at hand and what's stated in the amended complaint would be roughly around January of 2018, Your Honor, is when there began to be a buyback. I think that's when the repurchase of the loan occurred from our client. So that would have been the time that they became aware of the issue, which affected the title, which ultimately led to the buyback from our clients.
Why is that not the accrual of the injury?
And that's what I will get to in my second point, which I can go ahead and touch on, is that this court knows that in order for an action to accrue, there must be a breach of a duty and legally cognizable damages. Our second argument.
If your client was never required to buy the loan back, even if this went undetected, it could be a problem, obviously, but there is no real injury because your client's not forced to do anything.
Correct, Your Honor. And what our position was that breach of duty, no one argues that the breach of duty occurred any other time than in August of 2015 when the appraisal took place. What our position has been is that the damages of our client were not known until they suffered a legally cognizable damage, because the buyback of that loan ultimately could have resulted in either a net positive to them or a net zero at that foreclosure sale, which took place in June of 2019. Only upon that foreclosure occurring from the buyback did they know that they had a deficit, which they contend was a damage suffered by them at the hands or as a result of the appraiser. And that is our contention as to when our legally cognizable damages accrued. So therefore, our action would not have accrued until the time of the foreclosure sale in 2019.
Well, as in, let's just take a simple tort case, for instance. If you have an automobile accident with someone else and you assert that the damage was their fault, that they're liable, are you able to wait until you know all your damages before you file suit?
No, Your Honor, you are not, but you must be aware that there are in fact damages, presumably from the date of the accident. If you have attended a hospital or have accrued a medical bill, you know at that time you have some, whether that's $1 or it's $1 million, you know you have some damage. At the time of the buyback, our clients did not know that they had any damage that they had suffered, because only upon that foreclosure sale, which, as I said, could have netted zero or actually been a benefit to them had the property been sold for a positive or a benefit to someone, did they actually know they had any damage whatsoever. So the simple buyback of the loan did not result in a damage to them necessarily.
Why not? Because they were forced to expend money that they would not have been required to expend except for the problem with the appraisal.
Yes, sir.
Our position, they had to change their position in some way, and they had to spend money.
Yes, sir. And our position has been and is that only upon the resale of that property or the foreclosure sale where it was actually offloaded and the sale occurred did we suffer cognizable damages. But I understand where your Honor's coming from. That's actually the exact same scenario that was posed at the trial court as well regarding a traffic accident.
Right. Well, I didn't know that, but I admire the chancellor. He's a wise person. So
Yes, sir.
Anyway, go ahead.
Thank you, Your Honor.
Let me ask you, Mr. Lewis, because I don't know that you answered it entirely. So
Yes,
at the
sir.
time of the repurchase, was there a cost to your client when they repurchased the loan?
Presumably there was, because they would have had to have expended funds to repurchase the loan from the who initially bought it from them, which was AmeriHome LLC.
Okay.
So I believe that your honors are correct that in doing so, there would have been some cost to repurchase that because presumably they sold it at whatever the value was at the time and received funds for that and then had to give those funds back at the time. However, I don't.
Oh, I'm sorry. Go ahead.
I'm sorry. I was just going to say, Your Honor, I didn't mean to interrupt, that I'm not sure that that's set forth in the complaint exactly what the amount would be, but I think logic would follow that in repurchasing it, it would have expended some funds. Yes.
Which segues into my question, and that is, this case was disposed of on a motion to dismiss. Are there any facts that are disputed that are relevant to the disposition of this cause of action?
As to the timeline itself of when the negligence occurred, the appraisal occurred in 2015, when the buybacks occurred, and when the foreclosure sale occurred, there are no disputes as to what the timeline is between these parties. It is simply a matter of the application of the statute and whether it applies. And our position is that one, it would be retroactive, and two, in the alternative, if it does apply, then our client's cause of action did not accrue until that foreclosure sale.
Okay.
But I do not believe, to answer your question succinctly, I do not believe there is a dispute over the timeline, Your Honor.
Okay. Thank you very much.
That concludes my time. Thank you, Your Honor.
Yes, sir. You've got your rebuttal time. We will hear from the appellee.
Morning, Your Honors, and may it please the court. I'm Daniel King here on behalf of the appellees. And, you know, our position is, and I think Judge Stafford has beat me to the punch a bit, is that this is an issue of accrual. And that is the issue. And once we determine that issue, it takes care of the issue maybe that appellants have raised about having a vested interest. But the trial court saw it that way, and that's our position today. So we're asking that the court affirm the trial court's order that dismissed this action and remand the matter to the trial court for the attorney fee issue.
Let me ask you, Mr. King.
Let me, go ahead. Judge Armstrong, did you say something?
Yeah, let me ask you, Mr. King, you said it, you only look at when it accrued. What about the language in the statute that says accruing and conducted? Don't we have to read that in the conjunctive? So it's got to have accrued and been conducted.
Your Honor, I can find the exact language of the statute. I have a shortened version here that says that actions accruing.
And appraisals conducted on or after July 1st, 2017. Should we just disregard that part of it?
No, sir, but I think the way that I would submit to the court respectfully that we look at that language is that the accruing aspect is in relation to accruing of a cause of action. And then the language about or conducted on is a separate issue related to the actual factual occurrence that would lead to the accruing of an action. So I think it covers both situations where an action has already accrued and situations where an action would accrue thereafter. I think that's how I would submit to the court the language should be interpreted. So it covers both situations. And in this situation, the action had accrued in our position would be January of 2018.
And when was the appraisal conducted?
The appraisal actually occurred in 2015. And there was the first appraisal, and appellant's counsel, I think, referenced maybe June of 2015. But then it was in December of 2015, I think, is when there was a change made on the appraisal report. But either of those dates, sometime in 2015, is when the alleged negligence would have occurred. Okay, so that gets us, if you look at what the Supreme Court has said in Wyatt versus AC and S Incorporated, where it sets out a cause of action in tort does not accrue until a judicial remedy is available. A judicial remedy is available when, one, a breach occurs. So that would be the 2015 occurrence. But you also have to have part two, which is that breach causes plaintiff legally cognizable damages. And so it was in January of 2018 is our position when those damages occurred. And appellant's counsel makes the point, they want to look to the foreclosure sale and that it was a short sale, that they didn't recover their money, but they had actually already incurred an injury or a loss or damages back in January of 2018 when they had to react to and had to buy back the loan. And I think the Supreme Court's also set out that in John Cole and Company PC versus Dearborn and Ewing, damages sufficient to support a cause of action need not involve physical injury or an immediate monetary loss. Rather, cognizable damages may take the form of the plaintiff being forced to take some action or otherwise suffer some actual inconvenience, such as incurring an expense as a result of the defendant's negligent or wrongful act. And here, the appellant had to take an action that it did not choose to take. It was forced to buy back that loan. And it's our position that that was when the second prong of the accrual of an action occurred in January of 2018, when in fact they suffered those damages.
Are you saying then that this contingent liability in 2015 they sell the loan, or 2015 you've got the appraisal, the loan is sold eventually, but they've got this contingent liability? If there's a problem with this, they've got to buy the loan back. I know that's a gross summarization of essentially what the way things work, but why would the mere fact that the appraisal was wrong in 2015 and the existence of the contingent liability not be enough to satisfy this statute?
Your Honor, I think it possibly could be, but as to maybe different parties, because at that point in time, it would have been, I guess, the issue would have been between these creditors that were buying and selling these loans back and forth.
Well, didn't the ultimate responsibility for buying back the loan rest with the appellant's client?
Yes, sir, I believe so. And I think too, I'm sorry.
I'm sorry, I'm interrupting you, but let me ask this, because at my age, if I don't ask it, I'll forget it. Does it make any difference that they've got to jump through these hoops in the interim where we know where the ultimate responsibility for the loan is, if there's a problem with it, or the ultimate responsibility for buying the loan back?
Well, Your Honor, I think the law provides for that instance in that the statute of limitations is not applicable until the action accrues. And so until that second prong is met, until they know or should know, reasonably should know that they've been injured, that they've been damaged, the statute of limitations isn't triggered. So it takes that prong being met for the triggering and for the accrual of a cause of action, which then brings up the issue of accrual. When did the cause of action accrue?
And who has to know that they've been damaged?
The plaintiff, Your Honor. It would be my.
But what about the plaintiff's agents or the people who are contractually bound to the plaintiff?
Your Honor, I would submit again.
Imputed?
I'm sorry, Your Honor, I couldn't.
Is there knowledge imputed to the plaintiff? For instance, the person that the plaintiff sold the loan to finds out that there's a problem with the loan because they're contractually bound to the plaintiff. Is there knowledge imputed back to the plaintiff?
Your Honor, I would submit, I don't technically for sure know the answer to that question, but I would submit in this case, the facts bear out that these parties seem to believe so. There doesn't appear to be any issue between the loan holders who were then forcing it to be bought back by the prior loan holder. They all seem to do that without much hesitancy. So I believe they would agree, or at least in this case, the appellant hasn't disagreed or hasn't made that an issue, that that they would have that knowledge, and they would have to honor that knowledge. But even still, Judge, we're not taking that position. We're not trying to take it back beyond January 2018, when in fact this appellant was made aware of this issue. It was made aware because of the loan violation.
I understand that, but I'm thinking about the appellant's first argument that I cut him off on and started asking questions about his second argument, and that is that the retroactive application of this statute. So, well, anyway, let me ask you a question about this. The wording of the statute is fairly clear. Then you've got the compiler's notes that tends to add a layer or another, well, I'd say another layer of analysis here by using the word and. And Mr. Lewis, I'll let you address this in your rebuttal as well. How are we as the court supposed to look at that when the statute doesn't have a requirement, but the notes do?
Your Honor, it seems, from my understanding, that that application or that language has been applied, and that is the effective date of the statute. And that is sort of the watermark of which statute of limitations would apply in a case involving appraisal services. And so,
well, I mean, I understand what you said earlier in response to Judge Armstrong's question, but the compiler's notes say shall apply to actions accruing and appraisals conducted on or after July 1, 2017.
Yes, sir. And in this situation, our position is that the action accrued after July 1, 2017. Obviously, the appraisal itself didn't. But
are there two requirements there according to the compiler's notes?
Your Honor, our position is that it was meant to protect this situation and in situations, or apply in situations where the appraisal occurred after July 1, 2017.
Why would you even need that language?
Your Honor, I'm not
You've
sure.
got an effective date of the statute that says, well, I had it in front of me at one point in time. The statute says it's effective as of July 1, 2017. Isn't that redundant?
Yes, sir, it is. If it's in both places, I agree. Absolutely, it's redundant. And I would submit that the statutory language would be ahead of the compiler's notes. But in this situation, the cause of action itself, because of the damages prong, did not accrue until after that July 1, 2017 date. So I don't know that we get to that issue if we reach a determination that the action accrued after July 1, 2017. As to the vested right.
What's the legal significance of the compiler's notes?
Your Honor, I'll be completely honest with the court. I do not know. I do not know what weight they carry in the order of weight for statutes, rules, compiler's notes. I don't know where they fall on that chart, Your Honor. So I want to be honest with the court. I don't know.
Nor do I. That's why I asked the question.
Yes, sir.
Not trying to trick you.
Yes, sir. Again, as to the vested interest issue or the retroactive application, which appellants arguing would be a denial, an unconstitutional denial of their vested right in this cause of action. Again, because the cause of action accrued when it did in January of 2018, there's not an issue there as to a vested right. But even if there was, and I believe in our brief, we had stated, even assuming arguendo that was the case, the Supreme Court in Morris versus Gross had stated no one has a vested right in a particular remedy for the enforcement of a right of action, and thus that the legislature ordinarily may change existing remedies for the enforcement of rights, including those which have already vested, without denying due process of law, provided a substantial remedy to redress that right by some effective procedure is given. And the Supreme Court also provided in Bradley versus LaPena that there is no vested right in the statute of limitations in force when a cause of action accrues, and the period allowed for suit may be shortened provided a reasonable time is permitted to bring the action. And in this situation, with our position being that the action accrued in January of 2018, the statute had been in effect for approximately 6 months, and the appellant here had time to file their action, just did not file their action. And I believe the appellant here was looking to seek its own remedy without recourse to legal action. And when their foreclosure sale wound up short, then they decided to pursue legal action. And those were decisions they made, and they're responsible for, we would submit. So as to the attorney fee issue, we would just submit it on our briefs, but also point out that the motion to dismiss was filed within the 60 days after service of the first amended complaint. I see that it was leave to file that was granted on February 28th of 2020, and we filed our motion to dismiss on April the 28th, which would have been the 60th day. Leave was granted by letter from the trial court. Not sure on service. I couldn't really nail that down, but sometime either that day or thereafter. So we were within that 60-day requirement. Thank you, Your Honors.
Thank you. Thank you. We'll hear a rebuttal from the appellant.
Thank you, Your Honor. I'll direct my attention to the question the court asked, which I believe was, how does the court look at quote unquote and in the compiler's notes? And then the later question of how does the court even address the compiler's note in considering the statute? And I would unfortunately haven't looked at that necessarily as to what weight the compiler's note would carry in determining it. And just a brief look, it appears that is a direction for application of the statute, meaning typically the enactment date of the statute would state when it comes into effect. That is some form of direction, additional direction that you wouldn't normally have as to when a statute becomes applicable, and also in what manner is it applicable. In this situation, it seems to be very important that there is an and a conjunction in there that says that it is actions accruing and appraisals conducted. Our argument has been that the significant change and the significant effect upon the appellant's right is that the time to bring action, if this statute does not apply, would generally be the 6-year statute of limitations for damages to property resulting from that negligence, which would have put us well within the statute of limitations because that wouldn't have accrued until 2021. We filed our case in 2019. So by taking that away, shortening that time to 1 year, and then ultimately precluding our clients from filing suit is where our retroactive application comes in. I think the court is correct and on a good path, in our opinion, when you speak about a contingent liability, that the clients or the appellant did have some liability ultimately if there turned out to be an issue with this from the time that they issued the loan and it was purchased by a subsequent purchaser, which would have occurred well before this statute was in application in 2017, considering all of this action occurred in 2015 and 2016 when it was issued and subsequently purchased. So it's our position, and position remains, that when you look at that statute, it had the effect of shortening our client's ability or time within to file the suit. And it's our position it does not apply to our client situation, because this appraisal, it is uncontroverted that this appraisal occurred in 2015, if not 2 years, roughly 2 years before this statute was enacted or ever took effect. And because of that conjunction of accruing and appraisals conducted, it's our position that this statute had no application to this case. And our statute. Yes, sir.
I mean, you understand that the statute itself doesn't mention anything about when the appraisal was conducted.
You cut out a little bit. If you could repeat that, I'm sorry.
I said, you understand that in looking at the statute, it doesn't mention when the appraisal was conducted. It only talks about when the cause of action accrued.
Understand.
And let me ask you, also in your complaint, do you set out that you had to repurchase the loan in 2018? Is that set out in your complaint?
Paragraph 20 of the amended complaint states AmeriHome subsequently requested that First Community Mortgage repurchase the loan, which it did in January of 2018.
All right.
Yes, sir. Your Honor, I would just finish up by stating that the application, the compiler's note should be considered when considering application of the statute and how it should be applied. And that application would be retroactive to our clients. We request that this be remanded and reversed, and our clients permitted to proceed forward in the trial court. Thank you.
Thank you, gentlemen. We appreciate your argument. You've certainly given us something to think about and work with. And we will take this matter under advisement and attempt to render an opinion at the earliest time possible. Mr. Hebner, anything we need to take up before we recess to the call to the next case?
No, Your Honor.
All right, you may recess court then.
Thank you, Your Honor.
This honorable court is now in recess until 11 a.m.
Thank you, gentlemen. We appreciate your argument.
Thank you, Your Honor.
Leave.